Got it.
By the way, I create all of these slides. That's why they're pretty aesthetically pleasing. I'm kind of kidding. You put in the words and then it automatically suggests photographs. So this one, I think I just put association. But anyway, next slide, Bruce. Here's kind of our agenda for tonight. We'll talk about litigation trends. So when we first, I've been doing this presentation for probably 15 years. And about 3 years ago, Bruce and I went to a law conference that we go to every year, that is for lawyers who specialize in homeowner association and condominium law. And one of the most well-attended panels was on what are called nuclear verdicts. Who was the president that said nuclear? Which president was that? I always thought that was funny.
Harder.
Was it Carter? Yeah, nuclear. I can't remember, but nuclear verdicts. And some of them will scare you a little bit, but they do illustrate a trend, that lawyers and insurance professionals dealing with community associations have been indicating, which is there's an increase in lawsuits against HOAs and condos. And some of these verdicts well exceed the policy limits of a lot of these association policies. Then we'll talk about insurance coverage, handling claims, and then also dispute resolution. But really, the big topic and the number one way to avoid liability is adequate and appropriate insurance. And Bruce and I tell we tell all clients, not just you, anyone that's needs insurance, when they ask how much insurance should we get, and our answer is always as much as you can afford. Um, and actually, Bruce, before we go any further, you told me this week or last week about an association where their annual premiums skyrocketed. Will you share that just a little bit? And do you have any reason or understanding yet of why?
Um, I haven't spoken to the broker personally, so I sort of understand secondhand um, why. But essentially, is that that particular community is in, and there's been it's in Central Oregon, and there is a lot of commotion these days about wildfire risk in Central Oregon. A lot of communities really focused on firewise activity to reduce fuels. But and I'm not sure what agency or organization gives this rating, but essentially their community had a fire risk rating of 84, which I think it's on a scale of 0 to 100. So that their premium from the previous year to this year went, and I don't even know the percentage. It was 20 times more. The premium went up by 20 times. Which is outrageous. And I've heard of other, communities. We had that one on the coast, Kevin, where they were struggling to find any insurer whatsoever. Um, and we're nearly at the point where they simply could not get property insurance. There's absolutely a crisis of sort of within the insurance industry, serving common interest developments right now.
Yeah. And not just everywhere. I mean, there's insurance carriers that are completely pulling out of California because they view the risks as too significant. Anyway, we'll talk about handling claims in the event there's a claim and dispute resolution. All right, next slide, Bruce. Now, we say this at the beginning of all of these seminars, which is about half of you or so, based on the names I'm seeing, are in Washington State, and half of you are in Oregon. Um, the bulk of what we're talking about tonight, it doesn't really matter what jurisdiction. However, Oregon has some statutory requirements when it comes to what types of insurance. Um, by the way, those of you in Washington, um, pretty soon we're going to do a special seminar for Washington folks because of the new common interest statute that was adopted and takes effect Jan 1 and applies to all communities. So that's going to be a big change. And the other thing is, we recognize that your governing documents might differ from some of the statutory requirements. For example, if your governing documents say that you have to have a property policy with minimum policy limits of, 200,000 bucks, then that's what you go with, whatever your governing documents say, regardless if the statute says something different in terms of policy limits. All right, next slide. This one, I think this was in somewhere in the South. And there's a tree. This sounds like the start of a Zen proverb. There's a tree or a branch on common property and it falls. Who does it hurt? Well, it happens to that there's a child near the tree. And one of the important things about this case is that there was evidence that the board knew that there were issues with this tree for at least 2 or 3 years. I believe there were signs of decay that anyone walking by would have been able to recognize, and someone had reported it to the board, and the board did nothing. So the child gets injured. The parents file a lawsuit against the association. And look at that, $14 million jury verdict. Bruce, we need to be on the other side of the law and get these types of I'm just kidding.
What happens when there's a $14 million jury verdict in an association? I mean, nobody's got a $14 million insurance policy.
No, one of the, I can't remember which one, it may have been this one. The association had an umbrella policy that covered almost all of the verdict, but I think they were lucky. A lot of associations can barely afford normal insurance, let alone umbrella policies. I've seen cases where the association goes bankrupt, or a receiver gets appointed and the judgment gets paid over the course of decades. In any event, there's no easy way to deal with that if you get hit with one of these verdicts. All right, next one. Playground. This case made an impression on me because we had an association contact us just last week about whether or not it was a good idea for them to install some play equipment on common property. And yes, you can do that, but you got to be careful about it. Now, in this case, the playground equipment that they installed, it had malfunctioned twice before. By the way, do you see the theme here? The board had knowledge of stuff and didn't do anything. That's called negligence generally, right? Or breach of fiduciary duty. And they also, the board refused to pay for a maintenance contract. Now, one of the things that the case didn't address, sometimes the association just doesn't have money to do certain things. And when they go to the owners to special assess, which may require a vote, the owners shoot it down. So what do? Sometimes you just can't pay for stuff. But here, I think the critical fact was that the board had knowledge that the equipment that that was being used on the common property was defective. So $10 million in compensatory damages. You all know what punitive damages are? I call them punishment damages. So in some cases, and sometimes by statute, if you really mess up, and it appears maybe it was intentional, or the judge or jury thinks that you should have known better, they can sometimes award punitive damages or punishment damages. So $10 million in punishment damages, pretty significant. All right, next one.
Was this one Arizona?
I believe so, yes. Oh, yeah, this one, y'all know what a bollard is? So, often you'll see trails and there will be these usually 3-inch diameter metal pipe looking things sticking up to keep cars from coming in and out. And the bollards, and these ones, you could unlock it and the bollards would lower so that maintenance cars and whatnot could come through. And someone had reported to the board that the bollards weren't properly functioning. That it was an issue for not only cyclists and pedestrians, but also for maintenance vehicles to get in and out by lowering these ballings. So a cyclist is pedaled along, common property path, easement in favor of all of the owners to use and enjoy it, and gets hurt really bad. I think this injury resulted in the cyclist. He's a paraplegic now, wheelchair bound because of this, and $41 million. So pretty significant. Nuclear, as these are called. Let's do a couple of hypotheticals. A couple of on you here. Your associations have either asked for advice or we've done resolutions for what are sometimes called owner work parties. So let's say you got common property, landscaping's overgrown, you don't want to raise assessments, owners won't support an increase in assessments. So the owners at the annual meeting say, hey, let's just do a volunteer party and show up on Saturday with your power tools, your machetes, your chain, dangerous equipment. What do you think? Good idea?
If you have
I'm
workman's
biased.
comp.
Workman, yeah, that's just it. Yeah, and depending on what type of who your carrier is, sometimes your D&O policy, directors and officers policy, provides coverage for committee things, but this is a little different. This is just owners within the association working with dangerous things. Should you do it? What do you think,
Yeah.
Bruce?
Not without everybody signing a pretty properly worded indemnification and waiver agreement.
Yeah. Will you explain indemnification in the simplest manner possible?
Yeah, so waiver and indemnification are often confused. Waiver is when somebody, waives their right to sue somebody else. Indemnification is different. Indemnification is when somebody promises to pay the damages that somebody else might incur as liability. So, if it's this sort of situation where you're talking about somebody getting injured on the common property, you'd have them waive their right to sue the association for their own injury, but maybe also indemnify the association for the association's liability if, say, their child gets injured or their guest gets injured. That essentially you have the two different functions typically in one agreement. Was that clear, Kevin?
Yeah, I would say though, hand tools probably fine. Power tools probably a terrible idea. I think everyone in the community is better off just paying a little bit for a landscaper to come and do certain work if it requires power tools.
Do people use hand tools anymore?
You know, some people, I like hand tools. I'm also a master at all power tools,
You have
particularly
like a
to,
pair of garden shears that you go out and cut the grass with?
I do. I also, Bruce, as you know, have a 80 cc Husqvarna chainsaw with a 24-inch bar. Okay.
So if Kevin lives in your HOA, you should not have this sort of party.
No.
No. All right. Next slide. um, Bruce, I'll let you cover this. What is a fiduciary and what does it mean?
Fiduciary is a special relationship in which one party or person has essentially the authority to make decisions on behalf of another party or person. And then that makes you a fiduciary, and you have certain duties that come along with that authority. So you mainly a duty of loyalty and a duty of care to make sure that you're exercising that authority to act on that other party's behalf in a way that's in their best interest.
So, what does that mean in the context of board members and the association and the members?
I think that the term is used often a little bit too broadly or too commonly when it comes to board members. People always say we have a fiduciary duty to enforce the rules, for example, which I don't think is correct. you do have fiduciary duties, particularly when it comes to the finances of the association. So if you're collecting dues and you're holding that in a bank account on behalf of the owners, you do have a duty to manage that money in a way that is essentially in everyone's best interest, and you're a fiduciary in that sense. You're managing everyone's money. When it comes to things like enforcement, you typically don't have a duty. You typically have what's considered a discretionary authority. And I think people will often throw that term fiduciary duty out a little too often. And it, that same law conference that Kevin was mentioning earlier, one of the presentations that was given talked a little bit about how there are, if I correct me if I'm wrong about this, that essentially um, there are possibly circumstances where you may not have had a fiduciary duty, but once you say you've got a fiduciary duty, a court's going to agree with you. So you just want to be a little bit careful about throwing out that language too frequently. But the board is a fiduciary, does have fiduciary duties towards, particularly towards the finances of the association.
Now, one thing, I was on the board of my homeowners association. I was the president for a couple of years, and then there was a coup d'etat, and I was overthrown and exiled. No, I'm just kidding. Um, Mine is pretty easy going. We don't do much. We've got a little piece of common property that's about the size of a picnic table. That's it. But sometimes I wonder why many of you are serving on the board. It's a thankless job. You don't really get paid, and you expose yourself to some amount of liability. Now, that said, the law provides you some level of protection in your capacity as a volunteer director. And Bruce, the next slide, I have this down by memory, should be business judgment rule. Now, I'll let Bruce talk about this one as well. In addition, though, um, talk about what it means to have qualified immunity as a director of a nonprofit corporation.
Sure. Yeah, I mean, I think the qualified immunity is probably the stronger protection for directors than the business judgment rule, but they're very different things. But under the nonprofit corporation statute, there is an immunity for directors. Basically says that directors are not liable for anything other than gross negligence or willful misconduct. So, um, essentially, what that means is essentially directors are not individually liable for their own negligence when it comes to managing the affairs of the association. That does not mean that the association may not be liable for negligence. So, if the directors are negligent and that causes injury to somebody else, the association very well may be liable as an entity, but the individual directors will be immune from liability under that statutory protection. Now, it's qualified because it only applies to directors who are not compensated for their work as a director. So it's important that you're all volunteers in order to get those protections. Once you're compensated as a director, you now can become responsible for any negligence that you may commit. The business judgment rule is a little bit different. Business judgment rule is essentially a court-made rule that says that when it comes to the affairs and the governance of a corporation or an entity, that the court is going to be reluctant to put its own judgment in place of the director's judgment. So absent showing some, real bad faith or fraud or particular, either intentional or gross negligence, the court is typically not going to overturn a decision of the board of directors unless there's some egregiousness to it.
Well said. Now, Bruce keeps throwing out this word negligence, and keep in mind that insurance, particularly D&O, provides coverage when you make a mistake, negligence. All insurance covers negligence, mistakes. Now, no insurance, though, covers intentional acts. So that's a big difference. So if you know what you're about to vote on or approve or do is wrong and you do it anyway, there's not going to be insurance coverage for that if you get sued. So keep that in mind. Negligence implies you made a mistake. All right, next slide. Now, in terms of Bruce and I read a lot. We get also at this law seminar, and then there's monthly emails, reports of HOA cases from all jurisdictions, all 50 states, and so we certainly see trends in what's going on in terms of litigation, and these are in no particular order, except I've seen a lot of cases in the last year or two involving fair housing and discrimination, which, depending on your insurance policy, may be excluded. But other areas, premises liability, property damage, breach of contract claims are another area of liability. Some of you have employees, and that can certainly be its own minefield in terms of navigating the employer-employee relationship in the event you have employees. Now we'll go back to all of these topics as we continue, but let's go to the next one. Um, how do you identify what your risks are and what your areas of liability are? A lot of associations do annual surveys. A lot of our clients use SurveyMonkey. And when I first heard of boards sending out surveys to all of the owners asking for feedback, I thought that's nuts. You're going to get a lot of mean people saying mean things. And I would say by and large, I'm wrong. In fact, most of the survey responses that I've seen from our association clients actually are very constructive. And so surveys are a great way to identify risks. Some surveys will ask the owners to identify any issues that they've seen on common property over the course of the year. For those of you in Central Oregon, fire suppression, fire safety issues are often the subject of surveys. Financial statements are another one. And sometimes there is a very good reason to have a review or an audit. Now, we are not accountants, but there is a significant difference between a review and an audit. And sometimes when folks say they want an audit, what they really mean is a review. But anyway, you should talk to your accountant about that. But we often recommend that after turnover of the association from the developer to the owners. Or sometimes we've had associations where it's been the same directors for 10 years and there's a shakeup. Sometimes that might make sense to have some sort of financial review done at that time. Flow charts, we've seen wonderful flow charts. A lot of our high-rise condominiums have emergency preparedness pamphlets and brochures and website data for all of the owners. Inspections are another very important one, especially if your common property includes sidewalks or other areas where there is liability, playgrounds, trees, that sort of thing. And one of the things that's important about the business judgment rule is that you rely on experts when necessary. And depending on the issue, maybe it's your lawyer, maybe it's your accountant, maybe it's your construction expert, but use experts when necessary. And that's another way of shifting risk. Most of the experts that you all use have their own insurance. And if your expert's wrong, well, that shifts the liability from you over to that expert. Um, next one, and Bruce kind of covered this. So let's skip that. We can kind of, if we need to come back to that, we will. We got another hypothetical, though. So about 10 or 15 years ago at one of these law seminars I was just mentioning, there's always a course, usually 2 hours with insurance professionals and then the lawyers. And this always comes up because one of the exclusions under all of your insurance policies is what's called failure to timely tender. Now, tender sounds like something sweet, but it's not. Tender means notifying your insurance company of a claim. Then the question is, what is a claim? And the discussion that always comes up among association lawyers is something along the lines of, well, we go to a lot of board meetings, And if I had a dollar for every time an owner stood up at the annual meeting or the open forum at the board meeting and said, I'm going to sue you, be rich. And so do you tender when someone says that? And that's an issue that is very fact specific. And if there's anything that looks or smells like a claim, you ought to talk to your lawyer
Mm-hmm.
and determine whether or not it's something that should be that you should notify your carrier. So here, I don't have a good answer on this one. It depends on the circumstances.
Well,
You know,
Kevin,
go ahead, Bruce.
what I've been finding lately, particularly with D&O type claims. So, depending a little bit also on the insurance policy that's at issue. But if it's a property damage, you're almost always going to tender the claim. If it's some liability, somebody got injured, you're going to tender the claim. So it's really, I think, a little more questionable when it's D&O type claims where somebody's saying, you didn't have the right kind of meeting or you did something wrong. And but what I've been finding with D&O carriers is that one, the policies that I've been seeing lately don't have a requirement to timely tender, but just a requirement to timely notify. And I'm finding a lot of carriers will say, okay, thanks for letting us know. We're not going to open a claim unless you need us to.
That's good.
But then I think you've satisfied that prerequisite to coverage. So I would usually err on the side of notifying the claim, notifying the carrier. But I do think it's important to look at the policy language itself and see what the requirements are. The downside of opening too many claims is that your coverage doesn't get renewed or your policy, your premiums are going to go up the following year. So you do want to look at that and evaluate it and see whether you have to. But most of the time, I would err on the side of at least notifying the carrier.
Agreed. Now, or go to the next one. What do you think of this?
Drafted but not filed should, yeah, of course.
Yeah, notify, most likely tender.
Yeah, I mean, it's funny. Um, one of one of the associations that I represent has an owner who um, has a tendency to sort of prepare a complaint but not file it and kind of leave it on the doorstep. But he sort of has a history of doing that. And I know some of the people on this call actually know who I'm talking about, but so I'm not going to bring the person's name up. But in any case, I think most of the time you're going to have to notify the carrier. I suppose there may be circumstances where you just think this is not a serious threat, and we're not gonna do that. But problem is you can't really predict when that person is actually going to turn around and file the lawsuit, and not just be full of bluster.
Yeah. By the way, I was not paying attention to the chat box. Joel asked, what about paying one of the owners for mowing of the common areas? Uh, Honestly, I'd say it's risky, and I say that. So I grew up with this kid named Bruce Gold, and in the summers he mowed lawns, and then I don't know what was going on, but he stuck his hands under to try to get something out, and he lost both of his thumbs. Lawnmowers are dangerous. Joel, I'd say it's worth paying a few $100 for a landscaper with their own insurance to come out and just mow it.
If the owner is a landscaper and has
Now,
insurance, and they have
yeah,
actual
that's
business, no reason you can hire that company just because they happen to be an owner.
totally agree. I understood it as just
Yeah, I know.
an owner. All right. Now, the next one on negligence, we kind of covered this. This is a very nerdy topic. Bruce and I love this topic of negligence, though, and this concept of foreseeability. Actually, Bruce, why don't you summarize the Francis T case?
Oh, that's a
It's kind
really,
of a
really
sad,
bad
tragic
story.
case,
It's a horrible,
but
horrible case.
yeah.
So basic circumstance there. I was in California, was a condominium, had some issues in the neighborhood with break-ins, and they were known, and had some dark areas in front of the entryways. So one of the owners installed an exterior light on the outside of her unit without having obtained permission from the board of directors, and permission was required for any kind of architectural change like that. So the board sent a violation notice. And she said, well, I need this for security purposes. The board required her to remove it. And she removed it. And shortly after, somebody broke into her unit and she was raped. Um, and she sued the board of directors in negligence for essentially contributing to the risk, and won. Um, um, so it's a really horrible story, but it is, I mean, it is, there's a message there, I think, which is to understand if you're, negligence is all about risk and foreseeability of risk. And in that situation, where there were break-ins that were known, there had been security issues, um, and the board was aware of it, and basically this sort of risk was foreseeable, and then the board contributed to that risk through their actions, they can be liable in negligence. Now, again, probably not the individual directors, but the association liable for that.
Yeah. All right, next slide. We'll dive into insurance now. And then the next one, we'll talk about the types here. So the most common types of insurance that all of you are going to have are these: property, liability. Bruce and I call directors and officers D&O. And then fidelity. Now, your documents might call fidelity something different, or it might not address it, but fidelity insurance insures against theft of money. And a few years ago, we represented this condo association, a very small condo. And one of the board members had been a board member for nearly 20 years. And when she sold, someone started looking through records. And this gal, she was an older lady, but she had a debit card tied to the association's bank account. And for 20 years, not big purchases. She would fill up her gas tank, buy groceries. But over the course of all of those years, it was in the ballpark of 20,000 bucks. And this association had fidelity insurance, and they were reimbursed for all of those funds. And generally speaking, fidelity insurance is relatively inexpensive, especially if you get it through the same carrier that is providing your other insurance policies. Now,
One thing about, just
yeah,
real quick, as an aside on other insurance policies, and going back to your previous slide about when it makes sense to tender a claim under the D&O policy. So at the last CAI conference, I asked the presenters a question about that, and they didn't really have a good answer. But one of the individuals in the audience came over to me after and was like, "Hey, he was a CIRM. What does CIRM stand for?"
community insurance, something specialist, something.
Yeah, so he was one of those, and so he came over and he was like, what one thing that I recommend is, so a lot of association policies these days are just, it's kind of, you buy one package and it includes all of these types of property, liability, directors, officers, fidelity, and he said, it's done because it's cheaper, but it might make more sense to separate out your directors and officers policy as a separate policy, um,
Mm.
because if you have them all bunched together in one, and you're making a number of claims on your D&O policy, you might get a non-renewal for the whole package.
That's a
And
good point.
so if you think you're going to have a number of possible D&O claims, you've got contentious owners, you've got, you know, a lot of HOAs have that one individual who is just always going to tell you you're doing things wrong and is ready to bring a lawsuit. It might make sense to pay the little extra in premium to separate out the D&O policy into its own policy.
That's good advice. Now, very quickly, let me explain what these policies cover. So, property, let's say you have a clubhouse and there's a fire. That's where your property policy would kick in. If you're a condominium and there's property damage, that's your property policy. Liability is for property damage or personal injury, but slip and falls, those are liability um, insurance claims. Um, Sidewalk is icy, board didn't salt it or shovel it, liability policy. D&O is if you, as the board, get sued for decisions you make. And then fidelity, as I explained, is theft of money. Now let's go to the next slide and talk about some insurance terms. Insurance folks are like other professionals. They like
Hold
to
on,
use
hold
them.
on, hold
Yeah.
on. Real quick, just wanted to say one thing about directors and officers policies. It's something that often I find directors get confused about. Although it's phrased directors and officers policies, it's almost always more broad than that. It's going to cover the association as an insured, the directors, the officers, agents, and volunteers typically as well.
What
So
about architectural committee members?
yeah, so it's usually going to cover any volunteer.
Yeah, okay, yeah.
That'll include your committee members as well. Um,
But now, to be clear, Bruce, under the D&O policy, volunteer, it would be for decisions, not for using power tools and cutting their foot off.
well, typically a claim is going to be any demand for monetary or non-monetary relief.
But
So,
against, yeah, but it'd be the reverse. The volunteer is the one that would be getting sued and would be covered under the D&O.
right. So I mean, if somehow like the volunteer punched somebody,
Yeah,
then that means you probably have coverage both under your liability policy and under your D&O
yeah.
policy. But
Good point.
so
Good point.
Real
Um,
quick, we
oh
have a
yeah.
couple questions in the chat. I just wanted to see if we
Oh
could. We
yeah.
had a question from Peter asking, what about board members getting kickbacks from suppliers?
Ooh. If by kickbacks you mean some sort of financial or pecuniary benefit, that is likely a conflict of interest and is problematic.
it's definitely a conflict of interest. It would be certainly it would fall under the statutory definition of a director conflict transaction.
Yeah, yeah.
So what happens when you have a director conflict transaction? You have to disclose that relationship. So if now if all what do you do? And you know a director conflict transaction is not invalid as long as it's fair to the corporation and it was disclosed to the non-conflicted directors. So what do you do if all the directors are getting a kickback? I don't know.
Well, let's say they're getting a really good deal yeah. Yeah, and one of the other things is there's the legal definition of a conflict of interest, which Bruce just mentioned, and then there's the perception of a conflict among the members, and those are very different. And my advice is avoid even the perception of any type of conflict of interest. And then, hi Mo. Monica asked, does a charter to protect volunteers? I'm guessing what you mean is some sort of board resolution that says what the purpose of this committee or whatever is going to be. Um, yeah, I think that's helpful in terms of the volunteers have an expectation of what their role and obligations are. So yeah, I think
It
those are
may also
helpful.
it may also be helpful in terms of establishing that the people on that committee are volunteers that should be covered under the DNO policy.
Yeah. Oh, and then Sarah asked who should do a financial review? A CPA, and ideally one that has experience with community associations. There's at least two or three in Oregon. They also work in Washington that specialize in accounting for community associations. Go to the next slide. We won't spend much time on this, but terms. Um, and I bring this up because this gets confused often. So a claim might arise, the board calls me and I say, send me your declaration page. And in their minds, they're thinking the declaration of CC&Rs, declaration of covenants, conditions, and restrictions. But when it's in the insurance context, a declaration page is the one, sometimes two pages. It says your policy number, your policy period, and your policy period is very important. You'll notice that it will always end on midnight, right? And that's important. It'll have which policies you have, your deductible, and the policy limits. So it's a summary of your insurance coverage, and that's what is meant when we say the declaration page. Now, policy limits, those are going to be identified on the declaration page. And so for each policy, we'll have the policy limits, $1 million, $2 million, whatever. Now, another thing, often when I say to clients, send me your insurance policy, they send me the declaration page. That's not your policy. The declaration page is just the summary. The policy is a document that's anywhere from 20 to, I don't know, we've seen some really long ones, Bruce. And
Policies?
usually, Paul, yeah,
Right, very long.
and usually you don't even have those unless you've requested those at some point. So what your carrier gives you is your declaration page, not a copy of your actual policy. Occurrence,
Which,
there's a lot of
before you go on about that, in this, just we were talking about sort of the crisis in insurance that's going on right now. And in this market, if your association is facing a very steep premium increase in renewal, I do recommend getting the policy before you decide to actually buy that policy. So in the past, I think policies were a little bit more standardized. These days, I'm finding that insurers are writing more exceptions into the policies, more carve outs, and that one of we mentioned earlier we had a client on the coast that was having trouble getting insurance. When they did get insurance, so they finally got one bid, not the one they accepted, but um, when I asked for the policy and read through it, the exclusions had gotten so broad that I just felt like there was actually no coverage under the policy at all. And so I think in this market, with how insurers are reacting and kind of changing their practices towards common interest developments, it may be useful to get a copy of the policy before you decide to actually purchase it. It's not in all cases, but I think if you're getting a big increase in your premiums, that's a bit of a red flag that the insurer is looking at your association as a risky association.
yeah. Yeah. And I always joke that if you ever sit down and read your insurance policy, which if you have insomnia or you're really bored, you should do it. It's a little bit of mental gymnastics. And I always joke that it's a long document. The first 2 pages say everything that's covered, and then the next 50 pages are all of the exclusions to what they just said they were covering in the first 2 pages. I'm exaggerating slightly, but not much. Now, Bruce talked about indemnify. We've talked about tender. Now, the duty to defend. So your insurance carrier has two separate independent duties. The duty to indemnify you, meaning if you're found liable to pay the judgment, assuming it's covered, and the duty to defend you, meaning hire and pay for a lawyer. In a lot of claims, the duty to defend, in my opinion, is way more important because often your attorney fees exceed the amount of the claim. And so that duty to defend is very important. And under most policies, you don't get to choose who represents you. Your insurance carrier will assign that claim generally to what they call their panel. So pre-approved attorneys in the area who handle claims for that particular carrier. Sarah asked, what insurance documents, if anything, should be made available to the owners? We've had an owner ask to review our policy. Request seemed like a red flag. So generally, that's an association record, and if an owner requests the policy, they're entitled to see it. Now, depending on the situation, generally the rights of a member or an owner to inspect records is limited if it's clear that the purpose of the request is to harass the board. What's the language that's actually used in the statute, Bruce? It's not harass, it's
You're talking about Oregon statutes. I'm not sure that
Oregon.
language is in Washington statutes, but in Oregon statutes, it's that the request has to be made for in good faith and for a proper
Proper
purpose.
purpose.
So if you have reason to suspect that the request for the record is not in good faith and not for a proper purpose, then you don't have to necessarily produce the record. But I would think an owner wanting to see the insurance policy is likely something that they're going to have a right to see.
I agree. And even when boards have come to us and says, yeah, this owner is being kind of a pain in the neck and requesting stuff, my general advice is be transparent, If it's an association record, let them see it unless there's a really good, compelling reason not to. All right, next slide. Now I mentioned we've talked about this. Let's go to the next one. I mentioned the exclusions. Let's talk for a moment about typical exclusions under your property policy. Now, for condominiums, the property policy is much more important than a property policy in a single family home subdivision style HOA. But these exclusions are also going to be exclusions under your homeowner policy in most cases. Earth movement, war. No, can you believe that? That's still going to be in all of your policies. War is going to be, if it's a war that causes your property damage, it's going to be excluded. Now, water damage and mold are a very interesting coverage topic in insurance. In some cases, you might have an exclusion, but maybe there's what's called a rider, and a rider is generally additional insurance or an overriding of an exclusion. But often, if there's damage that's slow seepage or subsurface water, often it's going to be excluded. I had a case years ago. My client had bought a new house. There was a large rock retaining wall. And believe it or not, they're in bed sleeping one night, and one of these boulders, it was during a freeze thaw cycle. One of these boulders at the top fell off, rolled down the hill, and right through the bedroom window of the master bedroom. And we tendered the claim, and it was excluded because it was a result of a freeze thaw cycle. So lots of wear and tear is another one. Pollution cleanup often excluded. Let's go to the next one. Talk about common liability exclusions. Now, liquor. I would say, Deneen, one of the attorneys in our office, I'd say once a year we get a question from a board about whether or not it's a good idea at their annual meeting or their potluck to serve alcohol. The answer is generally it's a bad idea. But if there's a really compelling reason, you can get what's called a liquor rider. In other words, a temporary insurance policy for the purpose of serving liquor. Now, under that rider, that your carrier is going to make you have a licensed bartender and all of that. I would say, in general, terrible idea to serve any type of alcohol at any association meeting, whether it's a board meeting. Yeah, Bruce is looking at me and thinking, some of the best board meetings we've been to are usually at one of the board members' houses where all the board members are drinking wine and they laugh at all of our jokes. No.
Well, I mean, so I know a number of associations that will have their annual meetings at a restaurant or a club, like
I don't see an issue with that necessarily. But where the one that
they're not really the ones serving the alcohol.
That's right.
They're just simply organizing their event at a location that serves alcohol.
Yeah. So the one Deneen addressed, they wanted to have like a little mini bar at like a potluck after their annual meeting. Speaking of which, several years ago, there's an association that we represent that under their governing documents, there is an annual garage sale. And so they came to me and said, well, what happens, because we promote it, the association promotes the garage sale. It's under their governing documents. And they came to me and said, well, what happens if someone coming to the garage sale gets hurt, slips and falls? We went to their insurance carrier. They actually offered insurance coverage. It's called the event insurance. So like if you wanted to sponsor a fun run, it's very similar. But again, there's lots of insurance for unique circumstances. Now, other exclusions, contractual liability. So generally, if you breach a contract with a vendor or your manager, usually there's no insurance coverage for those types of claims. And then anything intentional is generally going to be excluded. Speaking of which, I love this story. The way Bruce and I first met, Bruce was, before he went to law school, managed homeowner and condo associations. And there was an association in Central Oregon that I was doing some legal work for, and he was managing. So he calls me up, and after a board meeting, two of the and how old were they, lady Bruce? The two ladies that got in the fist fight.
I mean, they're 50s, 50s or 60s.
Yeah, 56-year-old ladies. Yeah, things got heated at a meeting. They went outside, and one of them decked the other and knocked her to the ground. Which, you know, I love homeowners in condo. I love these. I mean, they're fun. People are interesting, but there's nothing going on in any of your associations that warrants assaulting someone. There's just nothing worth it. There's really no reason. There was one of my old firm when I first started doing this stuff about 20 years ago. I used to go to the annual meeting of this association near Prineville. And the first time I went there, I was still in law school. I went there with my boss, and a fist fight broke out. And I thought, what am I doing? I thought this was supposed to be a calm, intellectual area of the law. And then the next several years, they hired an off-duty sheriff's deputy as a sergeant of arms. And he just stood in the back. And I'll tell you, people behaved. It was interesting. Anyway. All right, next slide, Bruce.
There are a couple questions in the chat.
Oh, yeah, go
I
for
can't
it.
actually, I can't, I'm not sure if I can see them because of the way.
I can read
Oh,
them off.
There we go. There we go. All right, go ahead.
what if
Yeah,
it's a bring your own beer meeting? I would say don't encourage it, but if people bring a cooler of beer, what are you going to do? Don't encourage it.
I think if I mean the concern I would have is if the board were to sort of publish or promote the meeting as being a BYOB, like, hey, everyone bring your own drinks, then there may be some liability there in the event of injury. And again, negligence is all about foreseeability. So
Yeah,
I wouldn't necessarily organize a BYOB association event.
or promote it.
Yeah.
Yeah. Yes, we are recording this. Lucy usually gets these posted within 48 hours or so. Although this
yeah,
week,
will do.
as I said, for those of you that joined late, my birthday is Friday, and my birthday is similar to a federal holiday at Harker Lepore. The office closes down. We go to a very special lunch to honor me.
It's definitely BYOB.
All right, I think we're caught up on the questions, right, Lucy?
Yeah.
All right, next slide. Now, dispute resolution. We're running out of time. I'll go through these quickly. Mediation, I'm a huge advocate. By the way, some of you may have seen me on KGW Channel 8 a couple of months ago. A reporter reached out to me to ask me my philosophy on resolving disputes in homeowner associations. What I didn't know is the whole piece was about a very heated dispute, and I didn't know anything about. But what I said is, early on as a lawyer, I was pretty skeptical of mediation. Sometimes clients dig their heels in, and I just wasn't effective. But the more I did it, the more I saw that, yeah, there's value in having a neutral third party um, explain things to both parties. And, I always see it as it's also a way to see the weaknesses of your own case. But mediation, I think, is a very effective tool. Now, there's different styles. I went to one years ago in Camas. Things had gotten really bad in this homeowners association. So the board, they didn't ask me. They just said, we hired a mediator and we'd like you to come to this meeting. And it started out, she asked the mediator, she was a community mediator, not a lawyer or anything, but asked all of the folks at the meeting to briefly hold hands. And let me tell you how that went over. Not well. She was ran out of there. So when I say mediation, generally retired, semi-retired lawyers, sometimes retired judges. We use several mediators with experience in HOAs because some of the stuff that goes on, really great lawyers, if they've never dabbled in this area of law, often don't quite, even judges generally don't understand how these communities work, how the board gets elected, assessments, all of that. Um, And if mediation, now keep in mind, mediation by definition is voluntary. A mediator has no authority to make anyone do anything. They just try to facilitate negotiation, try to get the parties to come to some sort of agreement. Now, if at the end of the day, the parties do come to an agreement, generally the mediator will write out a settlement agreement. And once you sign it, then you're binding yourself to it. But the mediator has no authority to make you do anything. And then if you can't settle or come to an agreement, then it goes to generally litigation, court, and that gets expensive. Um, it's really no fun for anyone but the lawyers. But yeah, those are generally your ways to resolve those. Um, now we got just a couple of minutes. Some tips. Bruce, does the new Washington Kiowa authorize deductible resolutions? Do you know?
I'm not sure. I don't know
Okay.
that I've seen that in there. I'm not sure.
If you're in Oregon, no matter which type of community, you have the authority to adopt a deductible resolution, meaning if there's property damage, you can make the owner who benefits from your insurance policy pay a portion or all of the deductible. And if you go to our website and just search insurance deductible, there's an article about how those work. I also say review your insurance coverage annually. A few years ago, we had an issue where there was a gap in insurance. It wasn't renewed on time. There was a couple of months and a potential claim in between there. So those policy periods are very important. When it ends at midnight on whatever day, the next whatever policy you have, even if you're switching, needs to be lined up so that it takes effect immediately. Rely on experts, exercise the business judgment rule, but when things come up, use your discretion, talk to experts when necessary. Do surveys, walk the property if you have common property. For condominiums, have building envelope experts come out every couple of years and do a very thorough inspection. Um, and then, like I said at the very beginning, purchase and maintain as much insurance as you can possibly afford. And is there one more? Couple more tips here. Yeah, and then identify maintenance insurance and replacement obligations. Again, this is very dependent on what type of community you have. Some communities, just by nature, high-rise condominiums, for example, the risks are significantly greater than in different types of communities. And wow, I went 1 minute over time. I apologize. Marla, thank you. Appreciate your feedback.